Hello, everyone. Welcome to today's webinar. I'm Barbara Scafidio, editor of Prevue, and I will be your moderator for the next hour. I'm thrilled to welcome back our host, John Foster, an attorney, speaker, author, and legal counsel whose firm, Foster, Jensen, and Gully, specializes in the legal aspects of meetings and conventions, trade shows, and events, and association management. John has been an associate or general counsel for over 400 national and regional associations and companies since 1986. So talk about experience, you've got it right here. Today's quick housekeeping, today's session will be recorded and you'll receive a link via email. So don't worry if you missed something. And as with all Prevue webinars, you will receive CEUs from the Events Industry Council for participating. Speaking of participation, please do jump in with questions and we will hold some time at the end for a Q&A. So on that note, I'm going to turn it right over to John and we look forward to your expertise.
Thank you, Barbara, for your introduction. I appreciate it. Welcome to all of you. Good afternoon or good morning, wherever you're located. Appreciate you joining us for a legal perspective on planning meetings in a changing world. My own little personal housekeeping note is I'm actually had the flu and a chest cold for the last 2 weeks with laryngitis. And so I'm praying that I can get through this with my regular voice. So please be patient with me as I struggle through talking about some very important things that we're going to cover today. Let's go ahead and jump into it. I will take questions at the end, I'll tell you that. And the PowerPoint presentation that you're going to see is made into a PDF in the handouts that you can download. Toward the end, because I've got such heavy content, there's some ones I'm going to skip over, but the information that I would talk about are in the handouts and you can review them at your leisure back at your desk. But anyway, let's jump into this. We're definitely in a changing world and things are getting trickier. Although vaccines are here, the pandemic is over, but COVID is still with us for now. And the experts are telling us it may or may not surface in the winter time. So its variants are still with us and still have to factor COVID as well as the flu into meeting planning. Being a meeting professional today has never been easy, but to call yourself a professional today, you have to not only be an organized planner, know how to negotiate, how to run logistics, how to plan catering events, how to book AV. You also have to be a risk manager, and that's the key phrase today. Meeting planners need to be risk managers. What I'm going to talk about today will help you be a better risk manager, and this will apply to planners and suppliers as well. We're going to discuss a few risk management tips around, again, what's going on with COVID, flu, and so forth, and then some hotel contract terms at the end that you should be using and what to include in it. Again, whether you're a planner or a supplier, you have to embrace the role of risk manager and understand that planning meetings when you get large groups of people together involves risk, and it's your responsibility to plan accordingly. I need to interject at this point that although I've been a hotel director of sales and marketing for 4 major hotel chains, for the past 25 plus years, I've been an outside legal counsel, primarily representing and counseling meeting sponsors. Most of my clients are associations, corporations, and independent meeting planners. So finally, I need to say that, again, I've got more material and more slides than I'm probably going to be able to cover. I do want to stop a few minutes early and take Q&A, and I encourage you to download the handouts so you can have them to refer to later on. All right, since it's a legal presentation, I have to enter a disclaimer and say that the handouts and the visual presentation are provided with the understanding that I'm engaged in not rendering specific legal advice, but to give you some educational tips and points. And if you do have legal issues that come up, you need to discuss them with a legal expert of your choice, whether it's me or someone else in the industry. And that's familiar with your specific circumstances. So we're going to be talking about generalities today. All right, here's what we're going to discuss. What's going on in our industry and in our country, professional liability explained, 4 legal duties event sponsors have to their attendees, establishing health and safety rules for events and waiver events, and then waivers and assumption of the risk, how to use that as a risk management tool. Time permitting, we're going to get into some key issues and contract clauses, and then answer the question, what about insurance? It's a lot to cover, but we'll give it a good shot. All right, what's going on in our country and industry that you need to know about? The CDC has issued guidelines concerning gatherings. They update them periodically. Obviously, the guidelines, because the pandemic is winding down, more and more people are vaccinated. The guidelines are not as restrictive, but they still do have a whole section of the website on the CDC dedicated to risk management tips or health tips for large gatherings and meetings. And I'm advising you that you need to go to it from time to time. They have an app you can have on your phone that you can refer to them, because they still talk about social distancing. They've gotten away, obviously, from mandates for vaccines, but they still are recommending vaccines. And it talks about the 4 type of vaccines that are recommended, the 4 manufacturers. So I do recommend that you go to the CDC website periodically before each of your meetings and when you're putting together your registration material. I've got in here guidelines versus regulations. Sometimes the CDC enters advice that are guidelines only, which means they're not binding. They're just good advice and good guidelines to follow. Sometimes they issue regulations, but mainly guidelines. And so you need to, in your contracts, incorporate the guidelines and say that you have a right to follow the guidelines in order to keep your attendees and your staff safe. Vaccine boosters are being pushed, but they're not mandatory. Individual cities and states have removed restrictions on gatherings, but it's something that if we get more outbreaks, more variants that pop up in the wintertime, and God forbid if that should happen, nobody's hoping that that happens, obviously, but you need to be able to, in the destination you're going to, go to the state, the state regulations on what about meetings and so forth, and go to the cities. Usually it's the mayor's office or the governor's office on the state level if they've got guidelines. Right now they're loose. There are not any guidelines. There's no restrictions on travel out there. But again, it's your job now that the industry has gone through this to keep up with it. If there are outbreaks and so forth. If you plan international meetings, you can go to the Department of State as well as the CDC in order to see if there are any warnings on either the CDC or the Department of State about going to specific cities. Airlines are carrying full travel loads, but they've removed mask requirements. The public is being told that the pandemic is over, but that the COVID Omicron variant is still with us. And again, we may have a resurgence in the winter. So it's just something to be aware of, not trying to alarm anybody, because we're all want to get back to traveling in person again. All right, let's talk about, since risk management is the topic du jour, let's talk about professional liability, managing the risk. What players need to be aware of is understand the status or the requirements for negligence liability and how to avoid negligence liability. And the rule is this: we're not required by law to be perfect at what we do. We're not guarantors of attendee safety, but the law requires that we conduct our affairs without negligence by exercising reasonable care, called the duty of reasonable care. Now, meeting professionals are subject to this too. We all are. What is how do you determine what reasonable care is and what's negligent? Well, the deal is you need to know what other meeting professionals are doing in the same or similar circumstances. Your level or duty of care, reasonable care, is to meet industry standards, and that's why coming to webinars like this and other meetings and events, and networking with your friends that are meeting professionals, and find out what they're doing as far as safety concerns at their meetings. But again, planners still have some concern about holding in-person meetings, even though the risk is down, but there's always the flu. There's other areas out there. But if planners do get sued, it's usually over negligence. Negligence is defined as the duty to protect someone using reasonable care, excuse me, breach of that duty that causes injury or illness and damage to that person. And meeting professionals on both sides. I'm sorry, I'm gonna have to take cough drops. All right, so what are those legal duties you need to be aware of? You need to investigate all aspects of the event and take appropriate action to reduce risk of harm. Inform and warn attendees, plan for the safety and well-being of every attendee. And the last two are the most important. Take precautions not to subject attendees to unreasonable risks of harm. I apologize. All right, let's talk about best practices for establishing health and safety rules contractually. These are some tips for your website. Give your attendees an ample heads up if you've got health policies via emails, via website registration. Require them to click on them to agree with them. If you have policies that result in attendees being prohibited from attending, then that needs to be put on your website, and be very clear in describing what's allowed and what's prohibited and what's advised. I've got some samples that you can go through here. These are ones that were furnished by a large medical association that I do legal work for, and I thought they were good, so I incorporated them into this presentation. Vaccine requirements. About registering for the event, you want people to agree that they're fully vaccinated. 6 months ago, we were requiring people to furnish proof of vaccination. But now planners are loosening that requirement and just put the statement in there that people agree that they've been vaccinated. That's still a good idea in group meetings. And define what you mean by fully vaccinated. It means that they've had all their primary doses and recommended boosters, and that this should be done prior to the start of the meeting. And you can refer them to the CDC website as far as what vaccines are acceptable. So vaccine requirement, mask. Although masks are not mandatory anymore, but they are most planners are referring meeting registrants and their staff to abide by CDC and local guidelines regarding masks at the time of the meeting. Right now they're optional, but they may become stronger mandatory later on. Again, staff recommends that masks be used and a limited number of masks will be available on site. Sample policy on COVID-19 symptoms and testing. You're telling people that if they do have symptoms, they should be tested, 48 hours before they show up. And that if they are test positive, you're asking them not to show up, and that their registration fee will be refunded. Most large organizations for their meetings are having a limited number of rapid tests on site, so that somebody develops symptoms during the meeting. And you're telling people need to have a policy in advance on if people do test positive for COVID during the meeting. You're telling people they need to self-isolate, and that your staff can assist with hotel room transportation and returning home, and that that the organization will refund their registration fee, or they'll hold it for the next meeting. Make it their choice. Hand sanitation, the CDC is still advising, but not mandatory, that in large gatherings tells people if you're going to be shaking hands, and face it, that's what we do at large meetings, that hotels will have sanitation stations. And of course, you need to make sure that's in your hotel agreement, that hotels, and most hotels are doing it without being asked, but it's good to have it in your agreement anyway. And that you want your participants to represent that they've read these guidelines, these that I've recommended, but not, again, they're not, I'm not telling you you have to do this, but these are policies you should consider. And you want people to click on the box that says that they'll abide by all these policies, that they've read them and so forth. Let's talk about waivers of liability assumption of the risk. Um, what you see here is a sample waiver of liability. You're asking them to acknowledge that, it's inherent risk of exposure to viruses anytime you come to a meeting. There may be other hazards of injury or sickness that exist in any public space where people are present. And that, by attending the event, they knowingly, voluntarily assume all risk to exposure to viruses and agree not to sue the event sponsor nor the XYZ facility, nor any of the affiliates and so forth. There are longer versions of this, but this shorter version will work in most cases, certainly for, smaller meetings, but there are full page longer ones. And if you feel comfortable with, and prefer to use a longer one, then there are some available out there. I can help you with it. Let's talk about waivers for a second. You may have heard that waivers are not enforceable. Well, that varies from state to state, and there are guidelines you have to follow to ensure that they are enforceable. In most cases, they will be enforceable if you follow 3 rules. Number 1 is that they have to be conspicuous in size, the font, and the location. In other words, you can't bury them on page 22 of your registration materials and put them in 2-point type and expect to hold people responsible for that. They need to be in clear language. I think this one's clear. And they need to be visible where people can see them and agree to them. They need to be clearly written in, plain English. They need to articulate what the risk is that they're waiving, what the risk is that they're agreeing to. And this is a generic one regarding personal injury and, sickness and viruses and so forth. If you're talking about a sporting event, you would have a different waiver, a little bit different wording with more details on it about that. And the participant has to clearly and voluntarily agree to this in order to, in order to register for the event. They have to agree to this. If they don't want to agree to this, then I think you're obligated not to let them attend, because they'll be the first ones to cause problems if something happens. And it's their freedom, their choice whether to agree to it or not. If they don't want to agree to it, you need to put them on the sideline, because if you let them attend, then other people who had to agree to it are going to complain about that. You don't want that to be a problem. All right, let's go over, and I know I'm going sort of fast, but I got a lot of things I want to cover. I've come up with 10 clauses that I think are must use. These are not the only clauses in a hotel contract, of course, but these are ones some of you may be familiar with, some of them you may not be familiar with. But I call these, 10 clauses you might not be using, but you should be. And I'm not going to have time to get through every one of these, but I'm going to cover the highlights of some of the important ones. Hotel protocols and policies based on COVID-19 prevention. You might want to change that to flu prevention. Hotels warranty, hold harmless indemnification, insurance requirements. These are things that I'm recommending you put in your contracts with facilities. And if you represent a facility, if you represent a hotel on this call, these are typical things that you should be willing to negotiate and agree to. Obviously, attrition and cancellation for rooms in F&B is still a key terms. Force majeure, what I call force majeure, excuse of performance and termination. We'll talk a little bit about. Purpose of the meeting, expectations and assumptions. Purpose of the meeting clause is becoming very key, particularly during flu season and COVID. Guaranteed meeting and function space, protecting deposits and escrow accounts, demand for adequate assurance of performance, date change versus cancellation rebooking. That's something I pioneered a few years ago, and I use it in every one of my hotel contracts. And guarantee of quality of hotel services and adequate staffing levels. I'm going to cover probably 5 or 6 of these. I don't know if I'm get to all 10 of them, although we're making good time, so we'll see how far we can go with this. All right, the first one I've got in here is the hotel protocols. The purpose of this clause is to specify what protocols and best practices that you want the hotel to implement to protect attendees and staff in accordance with CDC guidelines and hotel policies, industry practices, certifications, and group requirements. And it's key that this clause specify what protocols the hotel is required to follow. If the hotel, and most of the big chains, if they have protocols that are published on their website, either attach them to the contract or incorporate them by reference. You see, CDC guidelines, hotel guidelines, and so forth. You want to make it clear that whatever guidelines they promise to follow, that's part of the contract, and that they'll be bound by it at a later time if there's a problem that comes up. All right, still in the same clause. State that the hotel warrants that all protocols and practices shall meet or exceed standard of care for the hospitality industry. That's what you're required to meet. It's the standard of care in the industry. And if somebody gets sick or injured and tries to hold either the sponsor or the hotel liable, then it's clear who's got what responsibilities. And then obviously in this situation, whenever there's potential liability, hotels should agree to hold harmless, indemnify, and agree to defend the group from any asserted claims for failure to comply with the agreed upon protocols and standards, as well as other risks. Hold harmless clauses are generally mutual, and the group should be willing to hold hotel to hold hotel harmless, identify and agree to defend them if the group does anything that causes the hotel to be sued. So they are reciprocal, and I think that's a reasonable way to do business. All right, as far as list of protocols and policies, there's several companies during COVID that came out. They're still popular during flu season and anything else, where most hotel chains have certifications now. I'm not going to go into a whole lot of detail, but Global Biorisk Advisory Council, or GBAC, um, have gone and certified, I think Hyatt Hotels, some of the other ones, have gone and certified that the hotels follow certain protocols. That needs to be incorporated into contracts as well. And if a hotel does not have a certification, you can find out what the bullet points are that these organizations certify by going to this website and ask hotel to agree that their facility does meet those specific requirements. Although COVID is gone for right now, this type of protection, hotel warranting cleanliness and group relying on it, it's now become an industry standard, and it's not going to go away just because the pandemic has gone away. Worrying about cleanliness in the hotel, being able to guarantee that to the planner, has now become industry standard and needs to be contractually covered. That's one of the changes. Talk about insurance requirements. Anytime you have an indemnification provision, you should always have insurance requirements to back up the indemnification. If there is a claim or a lawsuit, the insurance is there to pay for it and to pay off the claim. And so this is why insurance clauses that protect both parties, it specifies what type and what amount of insurance both parties are required to have. And again, this pays off any third-party claims that come up. So don't skip the insurance requirements. If a contract doesn't have the insurance requirements in it, if I'm representing the meeting sponsor or the planner, I'll add it in there. I'll also add the hold harmless clause in there if it's not in there already. This is one last tip at the bottom. This is sort of a technical in the weeds, but it's extremely important. Claims by the hotel or the group against the other for property damage should be limited to the amount of the property insurance required in the contract. This is a very standard risk management tip, that if the group's got $100,000 worth of property damage, if they kick over a can of Sterno and start a fire in a hotel, that the group is only responsible for the amount of insurance it has, and then the hotel's insurance would kick in and pay the rest of it. And this is very standard in property contracts. Okay, Um, Typically, the group and hotel agree to list each other as additional insured uh, or co-insured on each other's policies. Both parties are usually required to furnish their certificate of insurance to the other party. This is standard and should be in each group contract. All right, we'll move on to everybody else's favorite topics of attrition and cancellation. That's been attrition and cancellation aren't going away. The challenge is to make it reasonable to both sides. I've spent a lot of time in my career the last 20 years dealing with attrition and cancellation, how to specify damages, how to calculate attrition and cancellation, and we're only going to just gloss over the the highlights of the bullet points right now. My opinion is that attrition in guest rooms should be based on room nights, not on revenue. I know it's popular for hotels to ask groups to guarantee that they're going to spend a certain amount of revenue in room nights. I don't support that, and I realize it's negotiable, but I don't support that because the fact that groups that people calling in can get different rates. And was involved in a major lawsuit where the group picked up over 90% of its room nights, but it was $150,000 short in revenue because the hotel lowered the rates. That when people called in, they were able to get a substantially lower rate than the group had negotiated. And then the hotel just turned around and asked the group to make up the difference, even though they picked up 90% of their room block. I don't think the group should be responsible for the vagaries of the hotel's policies or vagaries in the economy if the hotel chooses to lower its rates. Again, that's negotiable. Current allowable attrition is between 20 to 40%. I recommend using best efforts clause with no room night guarantees if COVID or there's a major flu breakout that's still a threat to attendance. Depends on how if your meeting's planned a year in advance, you're not going to know that. But based on CDC threats or any other government threats about attendance at a particular city, if they're warning of it, and that keeps attendance from going there, then the clause should say that we'll use our best efforts to get people to stay there as the Equor Hotel, but you're not guaranteeing a minimum amount of attendance or room nights. Again, if meetings more than a year away, specify review dates when the group can revise block without liability. Specify when the block's final and can't be revised further without liability. And the percentage of allowable attrition to apply to the final adjustment date and go through the entire meeting dates. This is just my methodology. There are other methodologies out there, but to the clients I've represented over the last 15 years, this is the type of attrition clause that I recommend. Again, hotels sometimes want it a little stronger and they have a different way of calculating attrition, but this is the way I negotiate it for planners. Some other points of this: make sure the clause includes formulas for calculating damages. Most of the disputes in this industry over attrition or cancellation has to do with the methodology for calculating the damages. If the contract doesn't specify, if it does specify it, make sure it makes sense, make sure that you can put it on a spreadsheet, Excel spreadsheet or whatever, that you can take the clause and apply it to the spreadsheet. Actually, I came up with my clause after I put together a spreadsheet first and then came up with a verbal paragraph version of what the spreadsheet said. You need to make sure that every attrition and cancellation includes resold rooms in the formula, because what we're talking about is a liquidated damage clause, and liquidated damages can be a formula as long as the approximation of damages is reasonable. This is why 100% revenue for damages is never reasonable, never enforceable, because damages are based on net revenue, not gross revenue. In my opinion, attrition should be calculated on a per night and then added cumulative with credit for overage nights. In other words, damages should also be based on estimated lost profit, anywhere from 70 to 80%. Some hotels a little higher, some hotels a little lower. That's negotiable. All right, catering attrition. Make sure if you got catering involved in your contracts, make sure the clause includes formulas for calculating damages. Whereas room night, hotel rooms are based on room nights and not revenue. Catering is just the opposite. You need to stay at a minimum guarantee for catering in revenue terms. Guaranteeing $20,000 in revenue or $100,000 in revenue, depending on the size of the group. Now, hotels come up with their own way of calculating, depending on how much meeting space you use, what your minimum should be. But realize that that's negotiable with the hotels. It's not always smart to let the hotel set your catering revenue budget. But again, that's negotiable. Hotels have their own formula for doing that. I recommend to planners it's better to underestimate how much you're going to spend. That way, if you spend more than that, you look like a hero instead of a bum by going underneath it. Specify if the group spends less than the minimum, damages should be based on incremental difference between the minimum guarantee and the actual amount spent, and then put in the formula that amount will be multiplied by a figure to equal the estimated lost profit. In other words, here's an example. It's got $10,000 minimum guarantee. The group spends $7,000. The difference is $3,000 multiplied by what the lost profit would be. If it's 30%, then you do that math. Again, the difference is the fact that hotels and catering, until a certain date, the hotels haven't bought the food. And if you lower the attendance with the hotel, lower your guarantee before they bought the food, then you should only be responsible for the lost profit, not the cost of the food that they don't spend. Okay, if you got questions about this, we can talk about it. It's also important to specify in the catering attrition that if hotel is required to reduce any damages by replacement business from F&B functions it books after notification that the group will have reduced attendance or cancellation, that it could not have booked otherwise. And that includes other groups in hotel who expand or change dates to go into that space, because once that happens, then the hotel's prevented. If they allow another group in a hotel to expand or date change because of the cancellation, then they prevented themselves from reselling it to new business, but that needs to count as replacement business vis-a-vis the group that's in the group that's in the contract. Talking about cancellation by the group, the last section was mainly about attrition. But cancellation, attrition is just a subsection of cancellation. Attrition obviously is partial non-use of the hotel, and cancellation is total non-use. Damages for cancellation by the group should be mutual. Cancellation period should be mutual, but not reciprocal, because the numbers are not the same. If a group cancels, those damages need to be spelled out. If the hotel cancels the group's still entitled to financial damages, but it isn't necessarily the same as if the group canceled. So I don't support having them reciprocal, although I still see hotels proposing it, but that needs to be reconsidered. Cancellation needs to be differentiated from termination. If you cancel a meeting, it implies that you may owe damages to the non-breaching party. That's what cancellation's a breach, and the non-breaching party or the injured party may be entitled to damages. Termination, if you terminate a contract, it means both parties go back to zero and all bets are off. Termination occurs when a force majeure occurs. We're going to talk about force majeure coming up in the next couple of slides. But if a contract is terminated for valid reasons, then both sides go back to zero as if no contract existed at all, and neither side owes damages to the other if it's a valid force majeure leading to termination. Recommend establishing sliding scale to determine cancellation damages. Sliding scale needs to incorporate the percentage of allowable attrition and credit for resold rooms. Establish how lost revenue is calculated, including what rate will be used to calculate. In other words, is it the average rate? Is it the lowest single rate? Is it the how are you going to calculate it? That needs to be what rate is going to be used, needs to be in the contract. In most cases, sales tax should be excluded unless taxing empty rooms is required by state or local law. For many, many years, hotels did not apply, we're talking about sales tax, did not apply sales tax to a cancellation because no sale occurred. Some of the states have closed that loophole and require a tax if you had the right to use the room, but you didn't use it, you still had to pay tax on it. That can be checked out by the through the Secretary of State's office. I'm sorry, through the Department of Revenue, and in the particular state where your meeting is. You can either get your CPA to do that, or somebody like me can do it and knows where to go to get an answer on whether taxes are required on canceled rooms or canceled food functions. If the meeting's canceled and not rebooked, and the group pays damages, they should get credit for a certain percentage of those damages paid toward any future meeting it books at the same hotel within, I put down 5 years. That term is negotiable. Hotels would like it to be within the 12-month calendar year that you cancel. But sometimes, at least large associations, they've got their meetings booked for the next 2, 3, 4 years. And so that's negotiable, but that needs to be specified in the contract as well. Cancellation by the hotel doesn't happen often, but it does happen. I deal with it periodically at hotels. For whatever reason, they get a better piece of business. So whatever the case may be, sometimes they cancel groups. And again, that needs to be specified what those potential damages are, how they're going to be calculated. And again, it needs to be differentiated from termination. It's usually difficult to state a specific amount owed to the group if the hotel cancels. And the group is also still required to mitigate its damages by rebooking in a replacement hotel. So the group has to try to minimize whatever damages are. But the clause should specify what the hotel will pay to compensate the group for its lost revenue if attendance is less due to a replacement location, and any additional or increased expenses it incurs to rebook the meeting at a second hotel. Specify the hotels will return deposits to the group to individuals immediately upon cancellation by the hotel. Hotels want to hold on to deposits for a certain period of time, but they should be refunded to credit cards or cash back to the individuals that paid cash and back to the group at least within 30 days, but the contract needs to specify that. We're going to talk about force majeure clause now. This is sort of an overview of what the purpose of the force majeure clause. Obviously, it allows parties to, allocate risk and decide in advance what will or will not excuse performance. A force majeure clause is basically an excuse or performance clause. It says if certain things happen, we're going to talk about what those standards are, then the party so affected can excuse their performance without liability. And the contract law allows this, but it's important to specify what the details of that are, and I think most of you are aware of that. When applicable, the force majeure is a complete defense to performing the contract, and the act or occurrence must be outside the control of the party claiming the defense, whether it's hurricanes or bad weather or epidemics or diseases or whatever the case may be. It needs to be outside the control of the party that's claiming it. And the occurrence must fit one of the standards of excuse. And we're getting ready to cover that in the next slide. All right, the parties to the contract should list what triggers must be met before performance is terminated. And this is what the contract law allows. Performance is either impossible or illegal. Objectively means it's impossible or illegal for anybody, not just your group. Impossibility is a hard standard to meet, so there's some other standards. Illegal, everybody sort of glosses over that. But in 2020 and 2021, when the pandemic was raging robustly, a lot of states forbid meetings over 50 or meetings over 250 or whatever, or they banned all mass gatherings altogether by executive order of the governor or the mayor, and it made it illegal, therefore, to hold meetings that were outside those parameters. So that's where that applies. The other standard, the fundamental purpose of one of the parties has been frustrated because of new events. It's called the frustration of purpose doctrine. There's a lot more to it than that, but the contract clause says if the fundamental purpose of the party has been, frustrated, the contract can be terminated. But the rule is that the fundamental purpose that you want to complain about needs to be specified in the contract up front. For instance, if you're holding a golf tournament at the at the particular hotel or resort, and the golf course isn't available when your meeting's going to be held, then that's the fundamental purpose of the event. And as long as that's specified in the contract, or if the event is centered around an entertainment group or a particular speaker, if that particular group or speaker cancels or gets sick or whatever, and you therefore don't need the facility, then that needs to be specified in the contract. It's sort of a contingency clause. And then now the catch-all, and this is important too, performance is not impossible, but it's been made impracticable, which means substantially more burdensome than originally expected due to an extreme or unreasonable event occurring that the parties could not have reasonably anticipated, that is, unforeseen. Foreseeability is a big deal in force majeure. And this is why force majeure clauses have gotten longer and longer ever since 9/11/2001. Prior to 9/11, it was unheard of that terrorists flew jet planes into buildings, causing people not to want to air travel, not to want to travel temporarily. And so now, terrorist attacks and so forth are included in force majeure clauses, because if it's foreseeable, then your clause needs to mention it. This is why epidemics and diseases, all epidemics and diseases, not just COVID, but SARS and so forth, epidemics, diseases, hurricanes, bad weather, threats of war, and so forth. I've got a list of some of these things to cover, which I'm going to share with you in just a minute, and then stop for questions. But if it's foreseeable, the rule is if it's foreseeable, you need to refer to it in your contract. And this is why the contracts have gotten a little longer, because as more things happen, you want to put them in there. If it's unforeseeable and occurs, that's part of the terms too. All right, I'm not going to cover each one of these, but I've got some tips for preparing the force majeure excuse of performance termination clause. And the clause should be broader than acts of God. Can include other contingencies that must occur or not occur. They're significant to either party's performance of the contract. Parties must specify the impossibility standard. If you have impossibility in there, you need to provide for not only total impossibility, but temporary or partial impossibility, or a partial possibility, as well as inability. What does that mean? That means if your meeting's in January, in Chicago, and I'm sorry, say your meeting's in California, but you got a lot of people coming through O'Hare Airport in Chicago, and they have a snowstorm that closes the airport for 3 days. Well, the people that are flying through O'Hare, assuming they get caught at the airport or caught on short notice, that are unable to attend the meeting, say in good weather in California, that's a partial impossibility, because other people coming from other parts of the country that are not coming through that airport are able to get there. So you need to specify what percentage of people have to be partially impossible or partially can't come through there. And that's usually expressed as a percentage, 20%, 30%, 50%. The planners want that number to be lower. The hotels want that number to be higher. That's negotiable. But that's what partial or temporary impossibility. You want to include, terms like including but not limited to, and I've listed here asterisk whether actual or forecasted war declared or undeclared, or specific threat of war, construction or renovation. Again, including or not limited to government regulations, advisories, guidelines. This is where I was talking earlier about CDC. They put out advisories and guidelines, but they don't necessarily put out mandatory rules. Sometimes the federal government does put out mandatory guidelines, but the CDC mainly puts out voluntary guidelines. But since we're talking about health and safety, meeting planners should be able to rely on those guidelines, even though they're not mandatory. But that needs to be in your contract, that advisories and guidelines or quarantines will be recognized by both parties as a potential force majeure event. If you've got overseas meetings, I usually refer to the guidelines or quarantines or advisories about that specific country. Strikes, labor disputes, picketing, work stoppages need to be referenced in your contract. Change in hotel ownership or management company. If your if your group is particularly beholden to a particular hotel chain or a particular four-star hotel, but not necessarily a two-star hotel, and those hotels change ownership, and that's a big deal to you, that needs to be referenced in the contract. Deterioration of the facility where the meetings to be held, that's obviously more important to meetings booked more than a year out than they are for short-term meetings. Epidemics or diseases, which we're all familiar with, from not only in the city where the meeting is to be held, but also in cities or regions from where the attendees would be traveling. And again, if there's an outbreak in Chicago or outbreak in California, and a lot of people are coming through there, then the people who are affected and aren't going to travel from that particular city should be excused from attending, and that should be deducted from any attrition liability that may be owed. Epidemics and diseases are only one of the risks. So I came up with a catch-all that says any act or occurrence creating a significant risk to the health or safety of potential attendees. This is because we can't name every risk that's out there, or new risks come up, and you don't want to be real specific. COVID is the disease du jour right now, but we've also had Ebola, Zika, SARS. Who knows what it's going to be, the next one that comes around. And there's always the next one. We hope it doesn't come anytime soon, but there's always the next one. Loss of health permits at a facility and so forth, cancellation or restriction of commercial travel. If you have a large event that ties into a convention center, you want to link those to the inability of the parties to negotiate a mutually agreeable license agreement, or the inability or unwillingness of the convention center to provide actual use over the meeting dates. You want to make sure that's linked in your contracts. If you've got multiple hotels, I've got some guidelines in there for that. I want to talk about purpose of the meeting clauses. I had a citywide event that caused me to come up with this some time ago. This advises all parties of the purpose of the meeting and supports the frustration of purpose doctrine. I said earlier that you've got to say, the purpose of the meeting is to attract people in a certain industry or from a certain company or from a certain region to come to the city and meet, free from restrictions, free from, guidelines restricting meetings, size, and so forth. You want to put that in your contract so that if it occurs, you have it to point to as a contract term that would allow the parties to terminate the contract. You can go through and read what I've written there with some more guidelines. I also specify that something called that specify that, again, the group's expectations and assumption in booking its event at the hotel. Specify that it's important to the group that no material changes will occur to the reputation of the hotel or to the surrounding area that would materially frustrate the group's ability to accomplish its purposes, and the performance requirements specified in the contract, and specify that written surveys from anticipated attendees will be accepted to substantiate the claim. I'm going to just skip over this because I'm going to stop for Q&A in just a minute. Guaranteed meeting and function space. You can read some guidelines that I put down here. Be sure and get the handouts for that. Purpose of guarantee certain meeting space once the parties agree to it, and what there's some flexibility built into that. I recommend language if deposits are required, what kind of deposit schedule to have. There's a company that's come up in the industry called Meeting Escrow that will hold deposits in escrow for the group in the hotel. They're a neutral third party. Read through what I've written here. Um, Another guideline I've got that's in contracts today is demand for adequate assurance of performance. Both parties to a contract are allowed to demand performance from the other side or else hold them in breach of contract. And you can read through this. There's certain wording that goes into the contract and specify that failure to provide adequate assurances is an anticipatory breach of the contract there at the bottom. Another important provision I came up with several years ago, date change versus cancellation rebooking. I know this is contentious and somewhat controversial with hotels, but groups, if they, a lot of times, whether it's a corporate group or association group, they find out that there's a conflict and that they want to change the date of the meeting, say from March to April or March to June or May, whatever the case may be. The hotel considers this a cancellation and then you rebook it. But in some cases, the group considers it a date change. And I've come up with language that I think is fair to both the hotels and the group, that under the circumstances that the hotel will consider it a date change without damages if they meet certain criteria, like the meeting being booked at that same hotel or different hotel, the same owner, projected revenues the same or greater, the date changes made within X months of the first date, new dates are within X months or X years of the first meeting, and the hotel will use its good faith efforts to offer the new dates within the specified time period. And if those criteria are met, then the hotel will treat it as a date change without cancellation damages. The last one, which is extremely important that we learned during COVID, guarantee of quality of hotel services and adequate staffing levels. This is important to groups. Hotels should be willing to guarantee that staffing levels will be the same during the meeting as before COVID or before flu restrictions or whatever restrictions are out there. Specify, list of ratios of employees per guest and per guest room by the departments. You can go through and see the details that I have there. That's all the material I want to cover right now. I am going to stop for Q&A. I've got my contact information up there. If you want to call me or send me an email, if you got follow-up questions, I'll be happy to give you my input, give you my advice. I've enjoyed being with you. I'm sorry for the raspy voice, but I've done my best to get through all of it, and I'll do my best to answer your questions. So Barbara, if you did get some questions, let me know.
I do, but I think you should pause for a glass of water.
Yeah,
Thank
well,
you so much.
you don't have to drink to do this job, but it helps.
So the first question that popped up was the one that was on my mind as well, because we do events, Prevue does events in Florida. Regarding force majeure, this is from Teresa. Hi, Teresa. Regarding force majeure, if a group books business during hurricane season, would that impede their ability to invoke force majeure?
Well, I think no, it doesn't. Even if you book during, hurricane season, June, it's now going through November. It used to end in October, but it's now going through November. If you're there during hurricane season and a hurricane either prevents the property from providing its facilities or prevents the group from getting there, I think that's a valid force majeure, even though hurricanes are foreseeable. You probably should reference hazardous weather in your contract, but even though you booked during hurricane season, I don't think that prevents you from claiming a force majeure if it's factual.
Okay.
Does that make sense?
I've got another. It does, yeah. I mean, I think that the challenge is that I'm getting a lot of information on hotels now opening already after Hurricane Ian, but the experience for the attendees would be so altered so much
Well,
by
I think
attending.
I think you're right. I mean, it's on a case by case basis, and the parties, the group should have the right if the experience is going to be substantially less than what they feel they contracted for, then yeah, maybe they do have the right to cancel that particular meeting. Uh, it's not the hotel's fault, but it's not the group's fault either. And the purpose of
Right.
the force majeure clause is to say that both parties go back to zero, and neither side has to pay the damages of the other side because neither side caused the event that invokes the force majeure. I mean, you can get business, hotels can get business interruption insurance for that. Groups can get convention cancellation insurance, although it's going to cost you a whole lot more if you are booking during hurricane season. But you can try to get insurance for it. But both sides, neither side should have to pay the other side's damages in that situation.
Okay, helpful. Here's another one. This person would be interested to know what, if any, clause could be utilized in contracts for extreme issues in cities, such as a bad homeless situation that makes attendees feel unsafe to attend.
Yeah, I've dealt with that. Yeah, I mean, any situation can be created in the contract. You'd have to be specifics, and so it's not generic. You'd have to say, a homeless situation that comes up after you sign the contract. Presumably, you've done a site meeting, before you book there, and if there's no homeless situation around the hotel or the convention center before you sign the contract, and one develops later, and you want that to be an issue, you have to specify whether you just the existence of the homeless people are a reason, or does it have to present a health or safety issue? Does it have to be within so many blocks or so many miles of the facility? You got to be pretty specific about it, so that you just don't say,
Yeah.
homeless situation 10 miles from here gives us the right to cancel. That doesn't make sense. It has to be relevant to the venue, to the facility.
So based on what, this is a question from Susan. So based on what you spoke about today, should we still be acting as if we have safety protocols? Should we move forward but behave with a plan in place for a possible outbreak? So many meetings I've been attending have nothing going on with safety, with waivers, with testing. You know, what is the best course of action at this moment?
Well, that's a very valid question. The problem is we're in no man's land right now. We're transitioning from a serious pandemic to now no pandemic, but COVID's still here. And I'm being told that COVID's not going to go away. It's just like the flu comes every year. The COVID's going to be here for a while, and we're all going to have to get probably an annual booster shot. Now, having said that, um, my best advice is there needs to be some planning, because the industry, you need to look and check around, see what other planners are doing. That's what I'm saying. You're held to the same standard that other planners of your type of group. What are they doing under same or similar circumstances? Sure, you can go without any guidelines or hazards, but you put yourself and your organization at risk by doing that. That's the problem. What you're trying to do is reduce the risk, so that if somebody gets injured and you or your organization, mainly your organization, gets sued, you've got a defense and say, well, we did this, 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 and this, and that's all we can do. We're not guarantors, but you need to show that you took some steps. So what you're trying to do is reduce risk. You're trying to avoid the risk. You're trying to plan around the risk. And I think you need to have some guidelines on your website to say, at our meetings, we're recommending that you wear a mask, but we're not requiring it. We're recommending that you use hand sanitizer, but we're not going to come enforce it. But you need to have some guidelines. I think it's a mistake to say we don't have any guidelines.
Right,
So
right. Good
monitor other
advice.
groups, monitor other groups' websites, see what they're doing, and copy others. There, we're all copying each other at this point,
Right, right.
and there's nothing
John,
wrong
this
with that.
hour, no, no, this hour has flown by. I do have other questions. I will send them to you, and perhaps we can get the people responses individually. But I just want to thank you once again. It's always such an informative time when we spend it with you. So thank you for your time. Thank you, everyone in the audience, for joining us, and have a great rest of your day.
Thank you all for attending. Appreciate it. Goodbye.